Hello everyone. Welcome to lecture on Muslim law. I'm Marjina Sultana, an assistant professor from Interpersonal Law College, Greater Noida. Today we will be continuing our discussion on the applicability of Muslim law that we had in the previous video. So today we will be covering the basis of the application of Muslim law, the legislative enactments that have modified or abrogated the application of Muslim law, and the most important legislative enactment, that is the Muslim Personal Law Sharia Application Act of 1937, which governs the application of Sharia law or the Muslim personal law in India. All the rules of Muslim law or the Sharia law are not applicable in India. In India, the Muslim law is applied only in some matters, in personal matters only. The courts of the authority of the courts to apply Muslim law to Muslims are derived from or are regulated by partly by the statutes of the British Parliament, read with Article 225 of the Constitution of India, and mostly by Indian legislation. Thus, the applicability or the application of Muslim law is based on two, two things. First, on those that have been expressly directed by the legislature to be applied to Muslims, such as rules of succession and inheritance. The second ground, the basis is, are those that are applied to Muslims as matters of justice, equity, and good conscience, such as the rules of Muslim law of preemption. The legislative enactments that have modified or abrogated the Muslim law are the Indian Contract Act of 1872, the Freedom of Religion Act 1850, the Waqf Validating Act 1913, the Shariat Act 1937, the Dissolution of Muslim Marriage Act 1939, the Special Marriage Act 1954, when a Muslim solemnizes or registers his or her marriage under this act. So, under such marriage and the dissolution of such marriage, the liability of meher, the succession to the property of such Muslim are not governed by the Muslim personal law. The Indian Evidence Act of 1872, for example, Section 112 of the Indian Evidence Act is used by the courts in India. This Section 112 is applied in determining the legitimacy of children rather than the Muslim law of legitimacy. The Child Marriage Restraint Act of 1929 also abrogated the Muslim law in the sense that a marriage of a boy under the age of 21 years old and a girl of under the age of 18 years is a child marriage, and it is a punishable offense. But under the Muslim law, it is not an offense. So marriage is not a child marriage if a boy and a girl have attained puberty. So the most important legislation is the Sharia Act Application Act of 1937, in the sense that the application of Muslim law is concerned. So the authority of the court is derived from the Sharia Act of 1937, which we are going to discuss in the next slide in detail. The Muslim Personal Law Shariat Application Act of 1937 applies to a number of important matters in those cases where the parties are Muslims. Section 2 of the Act provides Notwithstanding any custom or usage to the contrary, in all questions, save questions relating to agricultural land, regarding intestate succession, special property of females, including personal property inherited or obtained under contract or gift, or any other provisions of personal law, marriage, dissolution of marriage, including talaq, ilah, zihar, lian, khula, and mubarak, maintenance, dower, guardianship, gifts, trust and trust properties, and the waqfs other than charities and charitable institutions and charitable and religious endowments, the rule of decision in cases where the parties are Muslim shall be the Muslim personal law, that is Shariat. So here I have underlined those matters in respect of which the court will apply the Muslim personal law. That is, the first matter is subject is intestate succession, that is inheritance. Second, special property of the females. Third, marriage, including all incidents of marriage. Fourth, dissolution of marriage, including all kinds of divorce. Fifth, maintenance. Sixth, dower. Seven, guardianship. 8. Gift. 9. Trust and trust properties. And the 10th, work of. So in these 10 subjects, the court will apply only the Muslim personal law, and this provision, this section 2 is mandatory. So the courts are not only empowered to apply Muslim law, but they are also bound to administer only Muslim personal law in the cases in these uh, subjects, 10 subject matter that I have underlined here. So the cases, those cases where the Shariat Act does not apply are colored in red. They are questions relating to agricultural land. So, gift and family settlements of agricultural land will continue to be subject to the customary law. And the another questions in which Shariat law will not be applied are charities and the charitable institutions, charitable and the religious institutions. And this the Shariat Act will also not be applied to those matters which are not expressly covered by the Act. For example, preemption, in which customs, of course, prevails. So the object, what is the purpose of this Act? The purpose of this Act is to, you know, to is to stop using those customs or usages which are contrary to the Sharia law. So those cases in which Muslim law applies are underlined here, and those matters in which Muslim law, Sharia law will not be applied are color in red. So it will be easier for you to answer when it is asked in the question in the exam that on which subject the Muslim law will be applied. So you can jot down these points, this subject matter, these 10 subjects, and if the question is asked in on which questions, on which subject the Muslim law will not be applied, then you can write down the matters that I have colored in red. So these acts, but the why these questions relating to agricultural land and the workups relating to charities and charitable institutions and religious endowments are excluded from the act, because the Shariat Act 1937 was enacted by the central legislature, so it was beyond its legislative competence to make laws for provincial state subjects. And these agricultural land and the charities and charitable endowments, being a provincial state subjects, had to be expressly excluded from the section 2 of the act. So these matter, agricultural land, charities, and the and charitable endowments are subject of state. State has the authority to legislate on this matter. So the courts cannot apply Muslim law on these questions under the authority of the Sharia Act. But state legislature are competent to enact laws on this subject matter. So in most of the states of India, therefore, the succession to agricultural land is regulated by the local tenancy laws and not according to the Muslim law of inheritance. The power to make a declaration. Section 3 of the Act provides any person who satisfies the prescribed authority that he is a Muslim, that he is competent to contract within the meaning of Section 11 of the Indian Contract Act, and that he is a resident of the territories to which this Act extends, may by declaration in the prescribed form and filled before the prescribed authority declare that he desires to obtain the benefit of the Act, and thereafter the provisions of Section 2 shall apply to the declarant and all his minor children and their descendants, as if, in addition to the matters enumerated therein, adoption, wills, and legacies were also specified. It is clear from the provision of this section that adoption, wills, and the legacies, which are not mentioned in section 2, the courts will not apply Muslim law to all the Muslim in these three matters. That is, adoption, will, and the legacies. In the matter of adoption, will, and the legacies, the court will not apply the Sharia law because these are not specifically mentioned under section 2 of the Act. Okay, so to apply Muslim law under on these matters, on these three matters, the Muslim have to make a declaration that they want to be governed by Muslim law in these matters. So this desire must be expressed through a declaration to that effect, and the procedure for such a declaration is it has been laid down in section 3 clause 2 and section 4 of the Act. So it may be noted that the effect of such a declaration is that not not only the declarant himself or herself but also their children and all the descendants shall be governed by the Muslim in these three additional subjects. So if there is no such declaration by a Muslim that they want to be governed by the Sharia law in these three matters, the courts are not bound to apply Muslim personal law on these matters. So they may freely apply customs and the uses or the local enactments, if any. So it is clear that those matters which are specifically mentioned in the section 2 of the Act, uh, in those matters, the Sharia law will be applied, but those matters which are excluded from in the section, in those cases where the Sharia law will not be applied, and also to the matters of adoption, wills, and legacies which are not mentioned in the section 2, these in these cases also Sharia law will not be applied. But if a Muslim desires to be governed by the Muslim law, those Muslims have to make a declaration in the prescribed form as laid down in section 3 clause 2 and section 4 of the Act, that they want to be governed by the Muslim law, not by the customs or uses or any enactments. So unless the declaration are not made uh, as per this section, the courts are not bound to apply Muslim law in these three matters: adoption, wills, and the legacies. So this is the end of the discussion on the applicability of Muslim law. I hope the concept is clear, and thank you for watching.